Good morning, Canada. Alex Monahan here, Foundations Party, ineligible. And today's date is April 16th, I believe. No, it's to the 17th today, and it is a Monday. And I thought we just can continue off reading the Immigration Refugee Protections Act, like I've been doing for the last couple of weeks. So, excuse me. Seems like my voice is a little froggy, and I apologize about that. But let us continue where we left off. Variations of order, paragraph 82.1. A judge may vary an order made under subsection 82.5 on application of the minister or of the person who is subject to the order, if the judgment is satisfied that the variation is desirable because of a material chance in the circumstances that led to the order. Calculations of period for next review. Subparagraph 2. For the purpose of calculating the 6-month period referred to in subsection 82, 2, 3, or 4, the conclusion of the preceding review is deemed to have taken place on the day on which the decision under section 1 is made. Arrest and detention, breach of conditions. 82.2, subparagraph 1. A peace officer may arrest and detain a person resulting under section 82 or 82.1 if the officer has reasonable grounds to believe that a person has contravened or is able to contravene I don't know. I think it's contravene any conditions applicated to their release. Appearance before a judge, subparagraph 2. The peace officer shall bring the person before a judge within 48 hours after the detention begins. Order. Subparagraph 3. If the judge finds that the person has contravened or was about to contravene any conditions applicable to their release, the judge shall order the person detention to order A. Let's try that again. It's going to be a long day. Order the person's detention to be continued if the judge is satisfied that the person person's release under conditions would be injurious to national security or endanger the safety of any person, or that they would be unlikely to appear at a proceeding or for removal if they were released under conditions. B. Confirm the release order, or C. Vary the conditions applicable to their release. Calculations of period for next review. Subparagraph 4. For the purposes of calculating the 6-month period referred to in subsection 82, subparagraph 2, 3, or 4, the conclusion of the preceding review is deemed to have taken place on the day of which the decision under subsection 3 is made. Appeal. Paragraph 82.3. An appeal from a decision made under any sections 82 to 82.2 may be made to the Federal Court of Appeal only if the judge certifies that a serious question of general importance is involved and states the question. However, the appeal may be made from an interlocutory. I think I had a problem with this one before. Interlocutory. INTERLOCUTORY. I'm not trying to pronounce that one, but if you can offer me some suggestions, I'm definitely willing to hear them. Decision in the proceedings. Appeal by minister. 82.31, subparagraph 1. Despite subsection 82.3, the minister may, without it being necessary for the judge to certify that a serious question of general importance is involved, appeal at any stage of the proceedings any decision made in the proceedings requiring the disclosure of information or other evidence if in the minister's opinion, the disclosed would be injurious to the national security or endangerment of safety to any person. Effects of appeal. Subparagraph 2. Appeal suspends the execution of the decision until the appeal has been finally determined. Ministers ordered to release. 82.4. The minister may, at any time, order that person who is detained under any of the sections 82 to 82.2 to be related from detention to permit their departure from Canada. Protection of information. 83, subparagraph 1. The following provisions apply to proceedings under any sections 78 to 82 to 82.2. A judge shall proceed as informally as expeditiously as the circumstances and considerations of fairness and natural justice permits. B. The judge shall appoint a person from the list referred to in subsection 85.1 to act as a special advocate in the proceedings after hearing representations of the permits. Request from the permanent resident or foreign national and the minister, and after giving particular circumstances and weight on the performances of the permanent resident or foreign national. C. At any time during a proceeding, a judge may, on the judge's own motion, and shall on each request of the minister, hear information or other evidence in the absence of the public and of the permanent resident or foreign national and their counsel, if, in the judge's opinion, its disclosure could be injurious to national security or endangered the safety of any person. C1. On the request of the minister, the judge may exempt the minister from the obligation to provide the special advocate with a copy of information under paragraph 85.4 subsection 1b if the judge is satisfied that the information does not enable the permanent resident or foreign national to be reasonably informed of the case made by the minister. C2. For the purpose of deciding whether the grant an exemption under paragraph C1, the judge may ask the special advocate to make submissions and may communicate with the special advocate to the extent required to enable a special advocate to make the submissions if the judge is of the opinion that consideration of fairness and natural justice requires it. D. The judgment shall ensure the confidentiality of information and other evidence provided by the minister if, in the judge's opinion, its disclosure would be injurious to the national security or endanger the safety of any person. Throughout the proceedings, the judge shall ensure that the permanent resident or foreign national is provided with a summary of information and other evidence that establishes them to be reasonably informed of the case made by the minister in the proceedings, but that does not include anything that, in the judge's opinion, would be injurious to national security or endanger the safety of any person if disclosed. If the judge shall ensure the confidentiality of all information or other evidence that is withdrawn by the minister. G. The judge shall provide the permanent resident or foreign national and the minister with an opportunity to be heard. H. The judge may receive into evidence anything that, in the judge's opinion, is reasonable and appropriate, if it is inadmissible in a court of law, and may base a decision on that evidence. I. The judge may base a decision on information of other evidence, even if a summary of that information or other evidence is not provided to the permanent resident of a foreign national. J. If the judge shall not base a decision on information or other evidence provided by the minister, and shall return it to the minister if the judge determines that it is not relevant or if the minister withdraws it. And K, the judge shall not base a decision on information that the minister is expected from providing to the special advocate, shall ensure the confidentiality of the information, and shall return it to the minister. All right. I think that'll be the first bit for the first half of today's recording, and we will pick it up again in the second recording on clarifications. Thank you very much, and thank you for watching, and stay posted.